The third judgment to be handed down today concerns the appeal in the case of the Campaign to Protect Rural England, Kent branch, whom I will call CPRE, and the Secretary of State for Communities and Local Government. It is an appeal by CPRE concerning an order for costs in a statutory planning review under Section 113 of the Planning and Compulsory Purchase Act 2004. CPRE sought to challenge a policy in the local plan produced and adopted by Maidstone Borough Council, which allocated a site for mixed employment floor space. CPRE, in accordance with Practice Direction 8C, had to apply to the court for permission to proceed with the review, and had to serve the application on the Secretary of State, the local authority, and the owner of the land in question as an interested party. Under the procedure laid down in Practice Direction 8C, the defendants and the interested party have to file an acknowledgement of service and summary of the grounds on which they contest the claim if they wish to take part in the statutory review. A similar procedure exists for applications for judicial review under Part 54 of the Civil Procedure Rules. The Secretary of State, the local authority, and the interested party each filed such documents. The judge refused permission for the review and made costs orders in favour of each of the defendants and the interested party, subject to a costs cap of £10,000 in aggregate, in accordance with the Aarhus Convention, which limits the costs to be incurred in environmental claims. CPRE challenged the award of costs to more than one defendant, citing the general practice in planning appeals which the House of Lords laid down in 1995 in the case of Bolton Metropolitan Borough Council, that the losing party in such appeals would normally not be required to pay more than one set of costs. Court of Appeal dismissed CPRE's appeal, and CPRE now appeals to this court. In a unanimous decision, this court dismisses the appeal. I give the judgment. Lord Reid, Lord Lloyd-Jones, Lord Leggett, and Lord Burrows agree. The court reiterates the ruling which it made in the Queen on the application of Gourlay and the Parole Board last year. First, that the principles laid down by the appellate courts in relation to practice are matters of practice rather than matters of law. Secondly, that the responsibility for developing practice rests principally with the Court of Appeal, which hears more cases than this court and is better placed to give such guidance promptly and flexibly. And thirdly, that it is only in rare circumstances in which an appeal on costs raises a question of law of general public importance that it will be appropriate for this court to intervene. This appeal discloses no such error of law. The guidance given in Bolton Metropolitan Borough Council case did not lay down legal rules. It was guidance as to practice and related to the award of costs after a substantive hearing. It predated the introduction of the acknowledgement of service procedure in the Civil Procedure Rules. The qualification of the Bolton approach in subsequent cases which dealt with the acknowledgement of service procedure did not involve any error of law. The Court of Appeal did not err in their interpretation of Part 54 of the Civil Procedure Rules, which deals with judicial review, nor in their interpretation of Practice Direction 8C. The appeal is therefore dismissed.